Good afternoon, Advocate Roelofse.
Good afternoon, Chief Justice.
How are you, sir?
I'm well, thank you, Chief Justice. It's a privilege to spend some time with you, albeit virtually. Thank you, Chief Justice.
Thank you very much. I see that in your earlier days, you really went all out to acquire qualifications, BCom Law, Diploma Juris, BProc, LLB, Postgraduate Diploma in Financial Planning.
Yes, Chief Justice, it took me 18 years from the first day I started university, bright-eyed, to become an advocate, Chief Justice. It took a long time.
And you've been an advocate for how many years now?
It's now 18 years, Chief Justice.
And you've acted as a judge.
Yes, Chief Justice, indeed, sir.
I see that you've attached quite a number of judgments that you wrote while acting.
Yeah, Chief Justice, yes, I was criticized about that, but I felt it was necessary that as much as possible was given to the Commission, Chief Justice.
And you are ready.
Yes, thank you, Chief Justice.
Thank you. Colleagues, let me have the names of those who have questions for the advocate.
Makwanisha, Dodovu,
Schlemmer,
Sigoba,
Hein,
I missed the last name. Oh, is that the Commissioner?
Jenny Kane.
Oh, okay. All right. Thank you. Thank you. Let's see.
Lamola,
Over to you, JP.
Thank you, Chief Justice. Advocate Roelofse, the first judgment on COVID-19 regulations came from Mpumalanga.
Indeed, so, Chief Judge President, that is correct.
You are the one who handed down that judgment during an urgent application.
That is correct, Judge President. That's
And
correct.
subsequent to that, you wrote full reasons for that short judgment and the order which you made.
Yes.
That judgment, and this is the only thing that I want to ask you about. You ended that judgment with the words Nkosi Sikelele Africa. What was going through your mind when you put those at the end of your judgment?
Judge President, that is how I felt. We were at the very beginning of COVID-19. The day that I considered the urgent application, only two people in
CJ,
South,
we can't hear the advocate. If
only 2 people in South Africa, sorry about that, were infected. 3 days later, many more were infected. And I was concerned about us and concerned about Africa because we do not have the same resources as the rest of the world. And we can even see today that countries that are well resourced. So every word there I meant. I wrote it because I felt that I also wanted to say the same prayer, Judge President.
Are you done, JP?
Yeah, I was done, but a wise man always changes his mind. and I've changed my mind. The last thing which you said, perhaps it goes together with what wise people say, and they say, when things are tough for people, think about how you can motivate and help them and not much about how you can navigate yourself single-handedly from the toughness of life. Probably that is what was going through your mind. Am I right?
Yes, yes, Judge President, it was difficult, and it was a difficult decision also to take. I was feeling for the applicant, but I had no choice but to apply the law because the law is our master and we must be the law's humble servants. The legislature legislated, the executive made regulations, and the court cannot encroach upon that. In any event, the basis of the application was not a challenge to the constitutionality of the regulations. It was, in effect, a request by the applicant that the court allow him to break the law. And that I wrote, that no court can allow any person to break the law under judicial decree. Now, I specifically used the words judicial decree because in past times, legislation was decreed by all the Kaisers and all the leaders, and the court is not there to decree. It is the legislature that's there to decree. The court is there to interpret.
Now, during your stay as an acting judge, you wrote a number of judgments, and the Chief Justice has already referred to that.
Yes, Judge President.
Have you ever had a reserved judgment for more than 3 months?
Judge President, there was no reserve judgments. 2 judgments, I've also included it in my pack, was delivered very late, but there were circumstances. It's where I sat with another acting judge who had to write the judgments, and it was not forthcoming, and my mistake was not to follow it up and to discuss it with you, Judge President. So, but for that, no reserve judgments. My judgments are delivered reasonably fast because I don't want litigants to wait. I've been an advocate for a long time, and it's very unfair for parties to wait for decisions of the courts, Judge President.
And what magic or weapon did you use to ensure that you do not have reserved judgment for a long period of time?
Judge President, I've included in my pack the list of judgments, the time the judgment was reserved, and the time that I've delivered the judgment. I've included a number of days that the judgment was outstanding, and the average time is 6 days for delivering a judgment on average. Judge President, there was 2 judgments that took longer. The one was difficult. It involved an estate and offshore assets, and there was no precedent on that. The other judgment took 46 days to deliver, but it was a judgment where you and I sat in an admission applications where difficult issues were raised. I was tasked to write the judgment, so it took a bit longer, Judge President.
You are aware that you are likely to be questioned about a reservation relating to your suitability to be appointed as an acting judge. Would you want to comment on that, or you prefer to wait for the questions to come?
Judge President, I know about the circumstances. It is most unfortunate, Judge President. I've tried to do my best. When the time had come when I had to disclose allegations that were made against me, I did so immediately to you. You took the decision that I could not be acting any further as a result of those allegations until it is resolved. You said in a mail to me, yet unproven. I wrote back to you, Judge President, where I said, I accept it. It's the best decision you could have taken, and that the law has spoken, and that I will abide. So, Judge President, that is most unfortunate that those allegations were made. Up to today, none of those allegations, no charges has been laid. But Judge President, that is indeed, as I say, very unfortunate.
The allegations were made by your own advocate society of advocates in Mpumalanga, am I right?
Yes, that is correct, Judge President.
Now, you don't have to explain the extent of it. Have those difficulties been resolved now, as far as you are aware?
Judge President, the issue is this, that the allegations were made. It came from a case over which I decided, I truly believe that the allegations were made in order for me not to preside anymore over further proceedings in that matter. However, the decision of the Judge President was that although no new matters would be allocated to me since the allegations were made, I had to finish with what I was supposed to do. And those matters came before me again. It came in the form of first a letter to the Judge President where a request was made that I be removed from all matters pertaining to the specific clients and parties. The Judge President said that there's no such thing in the law, that one judge can remove another judge from matters. So what happened is that I had to hear an application for my recusal, which I dismissed.
Okay.
Thereafter, I had an application for leave to appeal, which I dismissed. The parties then petitioned the Supreme Court of Appeal. Their petition was dismissed. I'm aware that at this moment, the matter, they applied to the Constitutional Court, and that for leave to appeal to the Constitutional Court, and the Chief Justice has issued directives only pertaining to an allegation in the other party's affidavit where a punitive costs order is requested due to the vexatious, unwarranted, and so forth, defamatory allegations that was made against me and also against the Judge President.
And you're aware that after a long period of time, almost like 9 to 10 months, the inquiry was made with the LPC as to whether there has been complaint which has been laid against you by the complainant in those allegations. And we were told that there was none. And thereafter, you're aware that the minister wanted to satisfy himself on your suitability. And you're also aware that in response thereto, he came back to say, according to the LPC National, there is nothing against you and there is nothing that can impede on your consideration for acting appointment. You're aware of that?
I'm aware of that, Judge President, and also the LPC commented that their members would welcome my appointment as an acting judge, that they found nothing untoward that is against me, and that there's no pending complaints. I might add, Judge President, that I also sent the complaints as well as my response to this commission. Immediately upon receiving it, I requested in my mails that the matter be dealt with. I've received nothing from this commission. I also sent the complaint and my response to the LPC and asked them to do what they deem necessary, because there's 3 ways in which the LPC can act. 1 is a complaint by the members of the public. 2 is a referral of conduct to them by a judicial officer. And 3, if they are of the view that there are serious misconduct, they can make investigations on their own part. Nothing of this has happened, Judge President. So as I'm sitting here, there are allegations. Nothing has been done about it, Judge President, and as a result of those allegations, the Judge President wrote in the letter, which I referred to in my judgment, that I would be acting for the rest of the COVID period, or the rest of the lockdown. As a result of those allegations, I was not invited to act. And Judge President, so that is where I am now, Judge President.
Okay. You are aware that there is a number of women who have also applied for the positions that you have applied for. And I suspect that you are going to be asked about transformation and the extent to which, if you are to be appointed, it will play a role. Now,
Yes.
Now I'm just, and it's up to you. Perhaps you might want to wait for those questions. Do you want to say anything as regards to the extent to which you think your appointment will accept some sort of significance in terms of transformation?
Judge President, transformation has a broad meaning and also limited meanings. Society must transform. We must transform to a society that's non-racial. There's no more violence against women, that there is economic opportunities for all. That is society that must change. But institutions must also change. The bench must change, but transformation is a means to a goal. And the goal is a bench that is a representative of the peoples of our country. In Mpumalanga, because that is where I applied for a position, 12% of people are white. The rest are of other color. In our division, there are already women. There is a judge president, deputy judge president, I've just heard that has been recommended. She made it clear during her interview that her aspirations is to become the judge president. It is wonderful.
Where did you get this? Oh, by the way, it's for public consumption.
Yeah, it is
okay.
published immediately. And I was with her when she got the news.
Oh, okay.
So Judge President, when we look at the bench in Mpumalanga, there are white people, there are women. It is a pity that there's not a white woman that is a candidate, because, of course, that would have been the better choice, to appoint a white woman. And I know, Judge President, as I've been acting, there has been white women. Currently, I know that there is a white woman that is acting, a very good judge. In my view, I've appeared before her, but she's not a candidate now. The other white woman that acted did not decide to come back. There was a colored woman that acted, and there were issues. So, Judge President, unfortunately, for purposes of these proceedings, I'm and Advocate Braakman are the two candidates that have applied, and unfortunately, we are both male, Judge President.
CJ, thank you so much, and I'm sorry for taking time.
Thank you, Judge President. Honorable Premier.
Thank you very much, CJ, and good afternoon.
Good afternoon,
Advocate
Premier.
Roelofse. I just have one question. Now, if you were to be considered for this position, how would you assist to transform the gender composition of the bench?
Premier, I use all opportunities when I have the opportunity to act. Colleagues that are with me, even senior colleagues, we discuss matters, and my door has been opened. There is commissioners that are here that can attest to that. When we speak about gender, I don't see the person. I see the office. The person is just the bearer of the office. That is how I was brought up. I will have respect for anybody. no matter if they are what color or what gender, because it's about the office they are bearing. So if anybody, doesn't matter who it is, would come and knock on my door and ask me to assist, I will do so. I've assisted with pupil training. As a matter of fact, I also, after the judge president invited me, assisted in the schools program, debate program that was hosted by the Human Rights Commission, where we taught and presided as judges over moot court proceedings, and I thoroughly enjoyed it. I enjoyed training, maybe for the selfish reason that the more I train, the more I learn. So, Premier, that is the small thing that I would do. Anybody would be welcome, and I would not see, and I do not see the person. I see the office.
Just as a follow-up, Chief Justice, I just want to check, given the vast experience that you have, how many of your colleagues that you have mentored thus far, and how far have they gone in terms of the ranking?
Premier, I've been involved in training of pupils from the start at the bar. I've attended courses and I've given training. I understand how difficult it is to access the advocate's profession. It was also difficult for me because you must remember that the advocate's profession are closely protected. When I became an advocate in 2003, I did not have money to do pupillage. So I acted without being a member of the bar. And I want to share this experience because there are many people out there that might find themselves discouraged. This is what happened to me. Advocates that are not members of the bar do not get proper briefs. There is a culture among attorneys, or was, that only advocates that are part of the bar will get proper briefs. However, one attorney, a prominent human rights attorney, Mr. Spoor, I'm going to mention him, approached me one day without being a member of the bar to assist him on a brief. The brief was about a road and a township development. I went and asked permission from a big attorney's firm to use their library. I got permission. When I took out the book about township development, a senior partner came in and asked me what I was doing there. I said, I'm doing research, I have permission. He asked me, are you a member of the bar? I said, no, and he chased me out. So I left, discouraged. The next day, and I want to share this because it's happened to me. I was on my way to Tulamars to defend a person that was accused of rape. When I exited the court, there was a big heap of building rubble. On top of that heap, there were 2 books. I went to the books, I've still got it. And the one book was the road ordinance, and the other book was the township's ordinance. And I had the materials. I asked the magistrate if I can have the books, and the 2 books I needed to execute the brief was placed there for me. I don't know how and how it happened. So that's why it is so difficult for people to access the profession. Pupillage is difficult. A year without income. I lived in Mbombela. I did my pupillage in Pretoria. I had to leave my family. I saw them every 3 months. And I had a household to run. But I wanted to do pupillage. And today I'm thankful for that partner that chased me out of his office or out of the library. Because if it was not for that, I might not have done pupillage. So, Premier, I've been involved in training throughout my career. At the Mpumalanga bar, I trained the first 6 pupils single-handedly. And I'm committed to that.
No, thank you very much for the response. No further questions, CJ. Thanks.
Thank you, Premier. Honorable Magonisha.
Thank you very much, Chief Justice. I think my questions were asked by the Judge President, but Advocate Roelofse, good afternoon.
Good afternoon, Commissioner.
Or good evening. The allegations against you, they are quite serious if they can be proven. What advice would you give us? Because I don't think that we can just pretend that they are not there. If, for instance, this body recommends you and those people decide to proceed and press charges, would you want a situation where a sitting judge would have to deal with cases of fraud whilst sitting in the bench?
Most certainly, Commissioner, I do not want that, but one must look at the circumstances. The relevant people had more than a year, or now it's a year, to lay the charges. I asked them in my response, please, lay the charges, proceed as you wish, because the interviews are coming, and this will seriously impact upon me. Commissioner, in all fairness, I immediately did what I was ethically obliged to do, because I'm bound by the authority over me. I immediately disclosed it to the Judge President, which led to me not being able to act invited, although he confirmed in a letter that I would be acting until the end of lockdown. I had no income because I had no practice left. I committed myself to my judicial duties. Then, up to now, no charges were laid, neither with the JSC or with the LPC. The LPC had all the allegations, and they confirmed that all of their members supports my appointment as an acting judge. So how long do I have to wait, Commissioner, for this to be resolved? I thought by myself, maybe I must lay a charge against myself. And that would bring it to the pass. I asked the JSE to deal with this as soon as they can. I asked the LPC to do so also, because the interviews were coming. I'm ready. I've worked hard. I've done my part. But I think through an attempt to pressure me into submission in decisions over the matters I was presiding was the only reasons for the charges being laid. Because after the Judge President wrote that he's not going to take me off those parties' cases, 2 days later the charge sheet came. So it is pressure that was exerted upon me. I did not succumb to the pressure. I wrote to the Judge President when he asked me, after a year has lapsed. He called me in November. Judge Mashile was not able to, he was busy, permanent Judge Mashile. If I was willing to assist for 2 weeks, I must decide, because it might happen that the whole thing will be resuscitated. I wrote to the Judge President and I told him that I'm sure it will be resuscitated, but if I succumb to pressure because I'm afraid what can happen to me, I'm not worthy of judicial appointment in any event. So I will accept any judicial duties he wants to give me. I accepted it. 2 days later, there was an complaint, and the judge president was questioned as how dare he again appoint me. I am not prepared to succumb to that pressure. And if the law has spoken, and the law at this moment for me is the commission, that I'm not worthy of judicial appointment, after all has been said, I will accept that. But I'm ready. I'm willing to do my part. I've still got 15 years left to serve the bench to the best of my ability. And it's in the hands of the commission. But I cannot be ransomed for the rest of my professional career just because people were unhappy with the decision that I took. The issue over the order that I made where all these problems arose is now before the Constitutional Court. And my thinking is, I might be wrong, through the directive that the Chief Justice has issued, only pertaining to the vexatious allegations that was made against me and the judge president. They wanted submissions on costs and punitive costs. I don't know what's going to happen, but my feeling is that my order is going to be sustained, and the Constitutional Court might want to express itself with due respect on the hijacking of the judiciary by allegations and interference, which cannot be allowed in our country.
Thank you very much, Advocate Roelofse. Thank you, Chief Justice.
Thank you, Commissioner.
Thank you, Honorable Magwanisha. Honorable Dodovo.
Thank you very much, Chief Justice. Good afternoon, Advocate Roelofse.
Good afternoon, Commissioner.
My question to you is to check whether in your deepest conviction, do you believe in Section 11 of our Constitution, that is the right to life?
I truly believe in that. I started my career in the prison service. I don't like to talk about this. I was a warden. I started there in 1988, the 2nd of February. I worked in Pretoria Central Prison, where the whites were kept. Pretoria Local Prison is where the black people were kept. And then there was the other prison, high security prison, and that's where executions took place. The last execution was in 1989 of Mr. I think Mbombela. The time I worked there, they were still executing people. I was a young warden. We were taken to the maximum prison, to the front of the gates. We had to stand there on a Thursday, because on Thursday it was execution day. And we heard the gallows fall.
No, it's okay. No, it's okay. I fully understand that you subscribe to
Yes.
to that section of
Yes.
our Constitution. No, it's okay. Now, the reason why I'm asking this question is because in 2004, and I'm sure you were just fresh as an advocate, you represented a woman in Bushbuckridge.
Yes.
That woman, as the allegations were going, she had injected her stepson with an AIDS injection,
That's correct.
and you chose to represent that woman. What was propelling you to do that? Or even before that, can you just share more about the case itself?
Yes, it was a difficult case. It was world news. It's the first time that such a thing happened. I could not refuse the brief because an advocate may not refuse a brief. Because imagine what would happen if advocates can choose who they want to represent and not. We have to deal with the most heinous crimes and represent those people. Otherwise, the promise that the Constitution gives, that everybody is entitled to legal representation, will come to naught. That is why attorneys can decide not to take on a client. Advocates are not allowed that luxury. If you have expertise and if you have time, you cannot say no. And that is what people do not understand, mostly. In that matter, I was assaulted by crowds outside Mala Court. I was hit with knopkieries. One day, when I exited the court, a crowd stormed me, and the only person that rescued me was a police captain who came between me and the crowd and shot with his firearm a few shots, and the crowd dissipated. So, did I like it to represent a person with that allegations against them? No. Was it my duty? Yes. And that is what public often do not understand. Because imagine if you are wrongly accused of a crime that is most heinous, and nobody, because they believe unproven allegations, is prepared to represent you. You are entitled to representation. It is not about the person. Life has taught me, my time in prison when I worked there, I did not spend time there. There was 2 attempts on my life because I did my job as a prosecutor. And you know who saved my life? A man that was convicted because he was an undertaker and buried his corpses in his yard in Mpumalanga and sold the coffins again.
Okay, no, it's okay.
So
It's okay.
not about the person.
It's okay. I think you have sufficiently answered me. Thank you very much. Thank you, CJ.
Thank you, Honorable Dodovu. Prof.
I think I'm covered, thank you.
Commissioner Sigogo.
Thank you, CJ.
Hello, Commissioner.
Good afternoon, how are you?
Well, thank you, Commissioner.
I'm good. You indicated that you have never been charged for the complaints that are leveled against you.
Yes, Commissioner.
But in the pack that I received, the complaints are in a form of a charge sheet.
Yes.
So was that charge sheet not executed?
It was not. It was a charge sheet that was issued by the chairperson of the Mpumalanga bar. I must say, it hit me like it took my wind out of my sails. But I immediately realized it's because I had to continue with the cases I was presiding over. So it was a charge sheet that was issued by the chairperson of the Mpumalanga bar. There was no decision by the bar council to charge me. It just came through. I resigned from the bar, and the commission has my reasons for that. Because I simply could not afford to pay 18,000 a month in bar fees while I earned nothing. And I did not want my debt. So it was not executed.
Okay, that is part one of my question. But then part two, when I read this charge sheet or the accusation against you, they are all about, they are mainly two.
Yes.
One, your failure to pay bar fees. Two, your choice to get a letter of good standing from the LPC as opposed from the Mpumalanga Society of Advocates.
Yes.
In law, Legal Practice Act, as we speak today, which body is the regulatory body of legal practitioners and which body legal practitioners are to pay their subscription as well as to be cleared in terms of letters of good standing, in terms of your understanding?
Thank you, Commissioner. I wrote a judgment which dealt with the admission of advocates and attorneys in the Mpumalanga province, and my opening words were out with the old and in with the new. Prior to the LPC Act coming into operation, it was the different law bodies, the bar councils, the bars, as well as the attorneys associations that had authority. Presently, the only authority over all legal practitioners, which is a good thing, is the Legal Practice Council.
Thank you. You need to stop there.
Thank
And
you.
Yeah, we will press for time. Thank you, CJ.
Thank you very much, sir. Advocate KNSC,
I'm covered, thank you, CJ.
thank you very much. Honorable Minister,
Can I add message?
thank you.
Yeah, thank you, CJ, and good evening, Advocate.
Good
Roelofse.
evening, Minister.
Yeah, I'm happy now I can put a face to the person. I've only interacted with you through papers.
I met you when the court opened, Minister.
And I did not know it's you.
There were lots of people.
Yeah. Advocate, I just want to ask you on this matter that Mr. Gogo has just concluded on. And I think the JP has also asked you at length on it. Don't you think you leaving the bar council after they've charged you creates an impression of someone who was running away?
I have dealt with that in my response. I gave my reasons for that. And my thought was, I disclosed the charges to the LPC, who was the real body that had control over my conduct. And I also disclosed it on my own volition to the General Bar Council, which previously was the only body that could apply for the striking off of advocates. And I also disclosed the allegations to this body. I said that it might be thought that I'm now running away by resigning from the Mpumalanga bar, but I did not. I resigned because I could not afford the bar fees any longer. When I was asked to act, I had no practice left. And you do not act for whole years on end. You act for 3 months. Attorneys can't get hold of you. You have to start your practice again. When you're not acting, it's very difficult. So that is the reason, and I clearly apologized, and it's in the pack that I've also provided to the Commission. So it's not to run away from responsibility. I clearly set out in all my correspondence that I will subscribe myself to any discipline because I consider myself bound to it, Minister.
Thank you, CJ. Thank you, Advocate.
Thank you, Minister. Advocate Mpofu.
Thank you, CJ. Good evening, Advocate.
Good evening, Commissioner.
How are you?
Fine, thank you.
Yes.
I'm terrified, but
yeah, well, no, don't worry, we don't bite. Yes, no, I just was interested when you gave that explanation of the cab rank rule. And I'd like to ask you about it because I was told that part of these sessions, because they are publicly advertised, it also help the people to understand our constitution. And we must thank those who have done it, like Judges Matter and people like that. Now, can you explain the importance of the cab rank rule and the fact that advocates cannot say no to clients, and the fact that if you represent a rapist, it doesn't mean you condone rape. More particularly in relation to, I think that misunderstanding, you said people don't understand it, stems mainly from not understanding the professional duty of an advocate.
Yes.
Because if you take other professions, can you imagine if doctors would say, I will not treat you because you are
Exactly.
a member of the IFP
Or-
or a teacher and say, I will only teach children
Yeah.
of my,
Or
of,
I don't
of my
treat-
church.
I don't treat people with runny stomachs. I mean, I can't do.
Yeah, can you just explain succinctly, very briefly,
the
where
principle-
it fits? In other words, if you are appointed, obviously you'll be in one area of the profession, which is the
Yes.
judiciary. But all these are parts of one chain. The attorneys have their role, the advocates their role, the judges their role, and so on. Interpreters their role, all prosecutors have their role. So I'd like you to explain the role of the advocate in that mix.
The advocate's profession is absolutely necessary. It was very important, and it's a very good thing that there's one controlling body. It will provide access to the profession. I hope that the LPC will do something about training and standardized training. And this issue of only giving briefs to people that are members of the bar is a thing that cannot be sustained, because you have a body of advocates out there where many problems arise because they are not bound. But so the LPC is a good thing. Advocates, there's a taxi or a taxi rank. What's the name? A cab rule.
Cab rank rule.
Cab rank, yes.
Yeah.
As I understand it, that an advocate cannot decline a brief. Only where he does not have expertise. So let's say I'm a civil attorney and now I'm confronted with a criminal case, I can say, I don't know that. Then he can deny it, or if he's already fully booked. Otherwise, he must accept a brief that an attorney brings him. He cannot say no, because that would be unethical and unprofessional conduct, no matter who the person is. And that subscribes the value in our constitution that every person has the right to be legally represented. And I consider it a noble rule. So you feel bad. I mean, I went to the hospital where that nurse worked. I saw the boy in court. I had to cross-examine him. It was the most difficult thing I had to do because he was ill. And I had to cross-examine him, but it was my professional duty to do that.
Thank you very much. Thank you, Chief Justice.
CJ, quickly.
Yes, thank you very much. Is that you, Honorable Malema?
Yes. No,
Please go ahead.
I wanted to reassure advocate that your first response on that issue was correct and was pointed, because you dealt with it properly and you gave proper example of people who will be accused here of murder. And when lawyers represent them, does the lawyers then love murderous people? No. You said it here nicely that you will be wrongly accused of murder. What happens? We must come and represent you. You are on point. I'll brief you outside. All right.
Thank you,
Briefing
Mr.
time.
Malema. I consider.
Thank you, sir. You are excused, sir.
Thank you, Chief Justice.
Thank you very much, sir. Thank you.